Hello viewers, I'm Advocate here. I work from LEXIS and Company. In today's video, we're going to talk about the writing. Chapter 8 of the Indian Penal Code 1860, which is dealing with the offences against the public tranquility under IPC. This chapter 8 consists of 22 sections 141 to 160, including section 153A and 153B. In this article, we discussed about the sections 147, 148, 150 to 160 of IPC. The offences of this chapter are generally known as group of offences and is the most of the offences are disturb the public peace or public tranquility. The offences of this chapter are classified into 4 categories. They are unlawful assembly writing. So in this particular video, we're going to talk about the section 147, which tells about the punishment for writing. Before discussing about section 147, the punishment for writing, we have to discuss about the section 146 of IPC. Section 146 of the IPC says about the writing. According to IPC, section 146 discussed about the offences of writing, and section 147 sets as the punishment of the offences writing. Writing is acknowledged as a right, being basically an unlawful assembly in a scrupulous state of action. That action being both with the exercise of force or violence, it is barely the use of force that differentiates writing or an unlawful assembly. Now let's talk about the ingredients of writing. Number 1, there must be an unlawful assembly, which is given in section 141. The accused must be a member of such an unlawful assembly. Violence must be used by the said unlawful assembly. In the important case Hazara Singh versus State of Punjab, the court held that the said violence must be used in the prosecution of the common object of the said unlawful assembly. In this section, the use of the force is a necessary condition to attract this section, as mere intention to use force does not suffice to hold a person liable for writing. According to IPC, if the common object of an assembly is not an illegal, then it is not a writing. Even if force is used by any member of that assembly, acts done by some other members outside the common objects are only chargeable against the actual perpetrator of those acts. The essence of this offence lies in the use of force to achieve a common design. If a group of persons assembled for any lawful purpose suddenly quarrel with the no previous design or intention, then it is not a right in the technical sense of the term. Similarly, it is not a right when members of an audience in a public theatre to make a noise or sound in a performance of the movie, but if the group of persons come prepared to interrupt the performance by causing a disturbance, this would be writing. Now let's talk about section 147, the punishment for writing. It prescribes punishment for writing, which may extend to 2 years of imprisonment or fine, or else both. I hope you are pretty much clear with this concept, and if not so, then do let me know in the comment section. I will see you guys super soon in my next video with some other legal topic. Till then, take care of yourself.